Right, so is that it? I think everyone's in it, aren't they? Wanted in.
Is Jamie connected?
Yeah.
Are you there, Jamie?
Jamie. Yeah, Jamie's there.
I'm there. I just was muted so that you couldn't hear background noise.
Actually, that's good practice too for anyone who isn't speaking at any given moment, especially if whatever's going on is generating any kind of background noise. Would be to mute up. It just makes for a much cleaner recording. So when it posts, you don't have 3 or 4 different audio streams at the same time with a bunch of background noise. So okay. And hey, one thing I just wanted to pass your way, Jamie, is that the most important thing is oh yeah, hey Fabrice.
Hi there. I'm just going to say I've not got a headset, so I'm going to stay muted most of the time because I can't trust my audio.
Well, I will tell you right now, you sound good. You sound check good as of now. So
okay.
So yeah, don't be shy in coming up. If you have anything to contribute, or if you want to take on a role, jump on in. It's I'm sure someone will let you know if the sound's getting a little off, and then you can meet up. But yeah, feel free to jump in anytime.
Okay, thanks, guys.
Great deal.
Cheers, mate, for coming in.
Yeah. Glad you could join, Fabrice. This ought to shape up well. So, but anyhow, what I wanted to convey was the most powerful, the most essential thing to understand. Oh, did we lose somebody? Oh, I guess we didn't add Gary Capps. Well, he'll come on if if he gets back to his computer. He probably just jumped away. But I'm sorry to continue. Fragmented at that is to understand why you're asking the questions, what you're asking them. All you're trying to do is find evidence being if somebody's murdered, you have a knife to prove that's evidence that that weapon was used to murder that individual, and then you could maybe pull evidence using fingerprints to link a particular individual to an identity and so on. So that's the type of evidence you're looking for, anything they can prove. Now a lot of times they'll refer back to the law. Well, the statute, proves this, or it's in the statute. Well, you have to remember that all statutes, all laws, constitutions are all legal, and when you talk things in legal nature, it's considered a legal opinion, and those opinions do have to be backed up by fact, and so, and of course by evidence. So what you're doing is you're asking, well, is there evidence of, in our case, we're talking about jurisdiction. However, like I suggested during the show, there's evidence of standing, corpus delicti, a valid cause of action. All these things that have factual elements, they have to be produced, or at least that they can point to or claim within the complaint somewhere, or give to you in the discovery process, whether it be a hearing or just a question during your arraignment, to prove these issues being raised. So, and what they're going to do is they're going to respond with, they'll either refer back to the law or the geography, that you're within the state or within the municipality. But they're not going to produce any evidence. They're just going to go back to the opinion or use logical fallacies. And so with the harder point beyond that is to bring them back and say, well, excuse me, I object, that doesn't seem like it's evidence. Maybe you need to specify, what you mean by the word evidence. So being very familiar with what you're meaning when you're asking for it, and say, I don't see where in that response they specified any particular evidence to suggest or to prove that these laws apply to me. Because to prove something generally is considered a contract, or at least that's how they like the PR is pushed, that it's consent to the governed, but there's no evidence to show that you ever consented to this. So it's really just their words and their assertions that, of course, because of civics class, stick pretty well in a courtroom full of people who have all been through the same state school. So it is an uphill battle to overcome that sort of psychological or educational programming. But once you could use, the objective thought process and say, well, what is actually being said here? What is actually being presented? Then it's easier to kind of decipher what's going on. So the premise is simple. You're just looking for evidence to prove applicability. And the burden is, again, on them. So a lot of and another thing they'll do is put the burden on you. Well, what evidence do you have that you're not a citizen or that there is not jurisdiction? But you got to remember the one bringing the complaint bears the burden of proof. And so when they try to put the burden of proof on you, again, you have to object and say, look, I'm not the one mounting a legal attack here or mounting a case. It's a prosecutor. They have the burden of proof. I'm not here to testify in any way, shape, or form. And, I would just prefer that we stick to the issues that I'm raising here that the prosecution must have to go forward with a case in the court, and that they should have to even bring a case to the court, kind of hinting at the judge's responsibility to validate these complaints instead of just taking them willy-nilly or, so freely as they do. So that's just a little bit I want to... I'm sorry, go ahead.
Yeah, I've been reading about that. I get that. My question, well, from what you said so far, I could have murdered someone and they could have the knife, and it seems like I could still be using the same argument. Well, what evidence do you have that the law against homicide applies to me? Even though they have a knife, I could still be asking for the same kind of evidence.
That's an interesting question, because Mark has talked about that before, and that's true. Technically, I suppose you could raise that case. But the problem is with that is that it's not a victimless crime, and a lot of the type of questions that we pursue are reliant on there being no victim, because as you may be familiar with, a valid cause of action or corpus delicti or standing, all those require some form of maybe loss, injury, harm, or actual damage to an actual adversary. So in those cases of murder where there is actually an adversary and there is actually evidence of corpus delicti, now you are right about the jurisdictional issue. Is there evidence of jurisdiction that these laws apply to us? Well, maybe not, but just like with the case where it's harder for them to go forward with a victimless crime because they don't really have any moral high ground to stand on. Now in a courtroom, if you're trying to appeal to a jury and to a court of peers, it's going to be harder to maybe mount that defense, because the prosecution could easily define and specify breaches of legal rights. Everyone has a right to life, liberty, and property, even though rights are fictions. You took life from somebody, in the case of murder. So,
right.
It's technically you're right. Could you use that line of questioning to challenge jurisdiction in a murder trial? You could. Is it going to work? Much less likely so than in a victimless crime situation. And in a victimless crime situation, you have the great benefit of being the victim. Go ahead. I'm sorry.
Oh yeah. My other preliminary question before any role play or anything else is just I'm wondering what the worst case scenario is, because what Mark was implying today was it would probably go to and appeal. It's $500 in Minnesota to file an appeal, and so that it's not, this ticket isn't worth the learning I've gotten so far is worth a lot. It's not worth $500. I mean, it's
right.
worth it, but I'm not going to spend that on the ticket. But I don't know if I spent that to go to appeals court, and he said most of them get thrown out in appeals court. Could I sue them for the money back at that point? Do you get the filing fee back or no?
I would have thought so. Yeah, if the conviction gets overturned on appeal, then you'll apply. Because generally it works under, and I think it does work pretty similar in the States. The thing is, with the worst case scenario, is sometimes, like we say, it's all about damage control. If it's easy for you to try and get the fine reduced, accept that, you end up having $500, and that's leave you alone, and all you've had to give me is $100, then fair enough, try and go for that. But the thing is with an appeal is you're guaranteed not to get a fair hearing.
One thing I would say about the appeals, Jamie, if you were to appeal it, it's not worth the $500 for you to put up for an appeal, and I get that. I mean, it's, and especially when you're going there all on your own and you're going in multiple times, and you're losing all this time by doing so. So I wouldn't say it would be less fruitless for you to go forward with the challenge to the prosecution. And I'm sorry, I you may have mentioned during the show, but is this a traffic ticket of some sort?
Yeah.
Okay. I mean, it's pretty minor. I'm sorry. Go ahead.
Handicap parking. Yeah.
Okay, so I mean, if you go, I'm sorry. Can you repeat yourself one more time, Jamie? You cut up a little bit there.
Yeah, everyone. I filed on Wednesday. I mailed by certified mail a motion to dismiss. I sent it to the judge because there's no prosecutor listed on this state of Minnesota versus me.
Okay, real quick, I'm going to interrupt you, Jamie, real quick. Did you call the court and try and attempt to get the prosecutor's name and where you can send the mail?
No.
Okay, that what you want to do, because you already filed with the court, Monday, call the court up. There should be a phone number, and if there isn't, you should be able to easily look one up online. Call them and ask them which prosecuting attorneys assign your case, and get their contact information. So because you're gonna, and the responsibility is on you really to make sure that you have all the paperwork filed with all the parties that need that paperwork, and the prosecutor certainly needs a copy of that. And without it, you're gonna have an issue in of that of itself. So when's this hearing? This week?
It's 1 o'clock on Monday.
Oh. Okay, well, they should have one. I guess, the best you're going to be able to do at this point is print out a copy and try and get it to the prosecutor. If you can't get it to them before the hearing, get it to them at the hearing. Say, hey, I filed this with the court. I didn't know how to get your information to get this to you as well, but here's what I have going. And what they shouldn't enter into arraignment even then. They should, if anything, schedule for a motions hearing, and you may have to move for this too. You may have to request a motions hearing from the judge when you go into court based on the motions that you have filed.
Yeah.
Okay, I'm sorry?
You went out after, if anything, they should schedule for a motions hearing.
Yes, they should schedule for a motions hearing instead of going into an arraignment or to a pretrial proceeding. So you shouldn't have to enter in a plea or anything like that on this with this motion filed. You should be able to just schedule it for a motions hearing and have the motion ruled on, because if the judge rules that he is going to grant the motion and dismiss the case from court based on lack of jurisdiction, then there really is no reason to have to get a plea from you or to proceed with any other proceeding. That's at least how it should go, and that's what you should convey to the judge if they seem confused, which is often the case. And when they get confused, as a prosecutor will, you'll start to see them glance at one another for visual cues on how to proceed. And how that usually works is they're going to say, okay, well, either going to give a blanket denial without giving you any grounds on the motion, or they're going to attempt to railroad you through, or the judge will do the right thing, especially with you having media reps in, and grant the motion to dismiss, or maybe set it for, a continuance and give the prosecutor some time to produce the evidence that you're challenging within the motions, which would be favorable in your case. So, but all that is dependent on you being assertive on what you're getting at through your motions, and constantly, every chance you get, if there's a pregnant pause in the courtroom or something, say, by the way, judge, I do object at this point and not every time will you have to put an objection if you just want to make a statement, but say, I just want to make note that we still haven't seen any evidence, produced by the prosecutor to prove any of his assertions. I mean, other than the violation of the ordinance itself, there's more to a justicable case than just an ordinance violation. There has to be standing. There's no standing pled on the ticket, but of course every judge understands that you have to have standing in civil cases. And if this traffic ticket's being treated as civil, then there you go. So it's there are legal elements that have to be met, or in requirements that have to be met for them to continue through. So any chance you get to inject that in there and really, bring the judge back to what the prosecutor's required to produce and prove, the better off you're setting yourself up for success. So, so I hope that helps. I'll include, everything that we discussed here. I'll include as part of the audio of everything that follows with the role play.
Really hard
too.
to hear you.
It's still hard to hear me.
Yeah. Let you out after if you object. Yeah,
oh boy.
I don't know if I'm the only one. Yeah, you're breaking up a lot.
Yeah, how am I sounding, guys? Vin, am I breaking up on your end? Because maybe Jamie just might have a bad connection. My connection has full bars, but anyone out there got a sound check for me?
You sound
Yeah,
fine.
you sound pretty good most of the time.
It's just after I ramble on for too long, the NSA doesn't want to hear it, huh?
You fill up your data pipe, man.
All right, too much truth for one breath.
Yeah, you just get
You'd think they'd want to record.
you just get kind of fuzzy on the ends there a little bit. That's about it.
Okay, well, either way, it should be clear on my recording. So, if you didn't get all that, Jamie, don't be too concerned at this point because you're gonna do your role play after this, and you'll have a clean recording of pretty much everything I said and everything everyone else has said to reflect upon.
Okay. That will help.
It'll be easier, but
Okay.
Okay, but I just really wanted to convey that having a core understanding of what you're actually getting at in court, the evidence to prove jurisdiction, and that it's the prosecutor's burden to do it and that they can't put it on you. It's hardwired so that when you walk in the court, anytime they deviate from that purpose, from the issue that you're bringing up, you could always come back to that. You don't, because I've had, early on when I took this material to court, sometimes you get lost in their legalese or in their, disruption. They'll divert. They're deceptive. They're dishonest. So there's a lot of room, and that's their intention is to get you off your train of thought. Because if that were to continue, if you were to complete your train of thought, it'd be very damning in their circumstance. Because of course they don't have the evidence that they should have. So they want to do everything, and they want to, and they will do everything they can to alleviate themselves from that responsibility. But if you have a core understanding of what you're getting at, and you understand no matter what they throw at you, just asking yourself the question after whatever they threw at you, did they or did they not answer my question or fulfill my request for evidence? And if the answer is no to that, as it often will be, then you need to follow up and say, I appreciate your response. However, that I object. That doesn't answer my question of the issue that I'm raising, whether it be jurisdiction, standing, corpus delicti, or any issue really. And on that note, do you have a script? One of Mark's scripts, Jamie?
Yes.
Okay, going over that will be helpful. Now, you don't want to go.
I have the questions. Yeah.
You don't want to go over every point in there, but you do want to kind of
No.
You want to kind of draft your own
Tell you
script.
the three approaches. Okay. Let me tell you the three approaches I've been told. First, John Miser said, well, you didn't file the motion in time, so you'll just have to skip right to trial. So I practiced. I wouldn't say practice. So he kind of gave verbal script. Doing they let dismiss it because I didn't give it to the prosecutor. And Mark said,
Okay, Jamie, can I stop you real quick
a
because
copy,
half of that
and,
isn't. Jamie, can I interrupt
yeah.
you real quick? Half of that isn't coming over.
Okay, so Calvin, should I try to tell you what?
Yeah, go ahead and with your question. I'm sorry about that. It was just bad on the other.
I just wanted you to know that you and Mark and John Miser all have different opinions about the when I filed the order to dismiss, since I only sent it to the judge. John said, oh, they'll never hear you. It's just going to go straight to trial. And we just barely practiced examining the officer. Mark said, it doesn't matter, just hand the motion to the prosecutor and tell them you're not ready to proceed to trial. It would be participating under threat, duress, and coercion because there's a motion pending. And then you said what you said. So I don't know if that matters for how we practice, but
well, I think we're all three kind of making different points. John's kind of right, and they'll just railroad you through. And the motion to dismiss isn't going to matter too much because they're not going to hear it. That's likely to happen. It happens often, but that doesn't alleviate them from their burden to prove evidence of jurisdiction. You got to keep in mind that the U.S. government has gotten cases thrown out of court, and I'm thinking mainly of the NSA versus ACLU for the same issues that we're bringing into court here. And this is something that we talk about at length on the show, is that there's, provably there's selective enforcement on their laws, because in one case you have the government who will file an almost identical motion dismissed for lack of standing or lack of jurisdiction in one of their cases, and it will be granted. And usually they don't even have to argue it too much. They'll file the motion, and the judge will simply grant the motion. That's when they're the defendant. Now, when the government happens to be the plaintiff in the prosecution, then it's a different story. Then they don't seem to want to evenly uphold their laws. And what John said as far as the motion to dismiss, they may railroad you through. They may not. And what that mostly depends on is how effective you are in arguing, and I hate to say the word arguing, but in making your points as outlined in the motion to dismiss, because as you know, it's been pointed out on the show, is that they should not be allowed to continue on with their case absent evidence of jurisdiction. And they'll tell you that, but they'll just assume it instead of prove it like they should. So John's right on that point. Now, Mark's point about, I'm sorry, what was it that Mark said again? You got to refresh my memory around this.
So Mark said that, yeah, it's too bad. He just said it doesn't matter that I filed it with just the judge because that's all I had, and to just bring in a copy. And then he said that when they try to start the trial, I just say objection. I'm not ready. I would only be participating under threat, duress, and coercion. We have a motion pending that needs to be heard.
And that's good right there. But let me ask you a question, and this is just kind of a quiz type question, but why aren't you ready to proceed?
Because you're wanting to proceed to trial, and there's a motion for dismissal on the table that hasn't been heard. Yes, that's absolutely correct. And you could, and this goes to more of the core of what you're getting at. You're not ready to proceed because the prosecution hasn't provided the necessary evidence to even bring this case into court. So there's that very fundamental element of it right there. But both of those answers are equally correct. But you want to make sure and make that point that the prosecution has failed to produce the evidence that it's required to have in every case. And if the judge is trying to convince you that jurisdiction can be waived, well, they're wrong. It's just, and that's when the appeal comes in, because sometimes you do get municipal judges that will say all these ludicrous, crazy things, which are provably untrue. I mean, you could bring, a damn law dictionary into the court with you and prove them wrong and give them court citations that contradict what they're saying. But with some of these municipal judges, they just like to sit on their throne and rule the way that they've ruled for years and years and years, because, before you and maybe a few other people, who has ever challenged them, especially in the way that we are challenging them on applicability. Usually challenges that are made at the court are made in a plea bargain fashion, or just, going on one legal issue or a technical issue with maybe speeding equipment or things like that. No one ever comes at it from this objective perspective. But I think this is the most effective way to go at it, because it really goes at their legitimacy. It goes at their authority, what authority they have established, that their laws, when I say laws, every time someone says laws, what should come up in your mind is legal opinion. When someone says laws, what they really mean to say is legal opinion. And the, functional word in there, the objective word, is opinion. It's not just because something's a law does not make it a fact. Now, not that facts can't be stated within laws. That may be the case, but a law is an opinion, and it's always subject to challenge. Now, laws of physics are pretty solid because you can challenge them, you can prove them, you can reproduce the results, things like that. Now, in the science of law, not so much, because again, you got that interpretive double standard. It may mean one thing in this case, and in a very similar case where the plaintiff and defendant may be switched, an opinion can be given just the opposite to it. So, but that's legalese for you. That's the interpretive nature of the law system. It's designed that way so that they can get what they want no matter what. It's just a layer that they have to hide, to camouflage the violence that they're perpetrating on their victims. And that being, whether it be you as a speeding, ordinance violator, or as a taxpayer, there's several vectors of how they have this layer of obfuscation, of disguise of the people that they're attacking for the various reasons why they're attacking them. Because rest assured, you're not being attacked just on the speeding ticket. You're being attacked every time you pay a tax. So it's just something that's really inherent in the system.
I hope that my answer, there was a good enough answer there for you.
Yeah. And so you said that I don't need to go in with my plea ready?
You need to. I'm sorry. Repeat that again.
Because Mark suggested just go in and have the guilty plea ready but unsigned.
Yes, the unsigned plea of guilt.
So you suggest I do have that?
Yes.
When I go in?
Oh yeah,
Okay.
absolutely.
What you were saying earlier there, Calvin, is the burden of proof's on the prosecution. The state's making the claim against you, so the judge and the prosecutor have been known to collude together, of course, and gang up on you. They may gang up on you. They may not hear your motion. The motion may never make it there, or they have, or they ignore it. Many different situations, depending on the judge, for sure.
Can I ask a quick question, though? Isn't the burden of proof upon them to prove that they can even drag you into the courtroom before you say, okay, I'll accept the invitation?
I would say yes, because jurisdiction has to be established before the court should be accepting the complaint. And by the court, I mean the judge. The judge should be taking these cases
to court. You just accepting that invitation has just given us jurisdiction. Sorry.
Yeah. So therefore,
you're there against your will, and that's all there is to it. Because if you don't show, they're going to send the man, the guys after you and come and get you and collect you and drag you in there. So.
No, not necessarily, because in England we are using special appearance, and all they end up doing at the moment is putting off the court hearing by between 6 to 10 months, basically.
That's interesting. I mean, I think what they're doing is by, administrative procedure, they're kind of screwing you guys, or putting, just like Vin James said at the beginning of the first call, is that the difference between the U.S. systems and the UK systems seem to be that you guys have a lot more, or many more steps, and much more procedure between the facts and the assertions. Whereas in the United States, you could more or less directly go to, but not that you can't do this there as well.
More of a dog and pony show.
Right, yeah, you could just go directly to the evidence right at the get-go.
We got the idea from America about the special appearance. And it's a lot harder for us to pull it off in England, because the way to achieve it over here would be for us to appoint the circuit judge to liaise on our behalf with the senior Crown County Court clerk, who is the guy who delegates power of attorney down the line to the statutory court judge if he doesn't get anything from us, and he clearly sees that we are waiting for the intended statutory court hearing. And it is by our silence and acquiescence that the senior Crown County Court clerk gets the power to say to the statutory court judge down below, this guy isn't posing any objection to the intended statutory court hearing. Therefore, I'm giving you the power to deal with him when the day arrives.
Well, I just don't. Well, I mean, as far as how we're going about it, there is a challenge to the authority. So I don't understand why that would be an issue here.
It's actually not an issue in America, because in America, if you want to get a hold of a county court clerk, it's very easy. Whereas in the UK, these guys are ghosts.
They're shielded, huh?
Yeah. we don't have a forwarding address for them. We don't know who they are or where they are.
Well, that really disrupts your notice and opportunity to be heard. Because if you can't interact with the court and file proper motions and paperwork, if they want to intentionally make it difficult for the sake of making it difficult, then it really knocks down the pretense. And I'm not sure if this is, exactly a legal principle there, but they're in America. You have
proper defense.
Right, yeah, you have to be able to be able to prepare proper defense and have notice and opportunity to be heard. And if they're obstructing that, then there's a case you could make. Now, how far it would go, we all can make our predictions, and I think we'd all be about right. It wouldn't go too far, but you can make a case for misconduct in that they're obstructing a fair hearing and they're not giving you proper notice and opportunity to be heard, and they're making it impossible for you to make your challenges, even to their authority, out there before, what they consider proper timing. So, and this is something that I thought of earlier, Jamie, that I want to bring up to you, is that when, if you get railroaded, you're going to want to be able to document and make a checklist, so to speak, or a list, while you're in court of, what, or in England, it's called, in America, it's due process violations. And what is it? An abusive process in England or in the UK? I'm thinking right there. But anyhow, in America, you're going to want to track all of the due process violations, because assuming the worst and you do get a railroading, and the prosecutor and the judge proceed absent evidence of fill in the blank, whether it be jurisdiction, standing, corpus delicti, valid cause of action, they're proceeding absent that evidence. And not only that, they're also, they're being deceptive. And when they're responding, they're giving you non-responsive answers. And then on top of that, what's likely to happen, I mean, these are all just predictions, but predictions we've witnessed come true almost every single time. They're going to pull out the logical fallacies, which again is a due process violation, because you are, after all, being very specific and direct in the question you're asking. You're being very honest and straightforward, and they are being completely the opposite with their responses. So it's not like they should be confused by your question. I think they understand what the implications of the answer to the question you're asking, and they don't want to have to deal with, or they don't want to have to break their dogma or their tradition of victimizing people, and instead they'll reply with logical fallacies or just complete nonsense. They won't be responsive to what you're asking, which of course is what evidence there is that they have to prove jurisdiction. And any other answer that doesn't answer that question is a non-responsive answer. So the evasiveness, the non-responsiveness, check, another due process violation. So maybe if you're taking notes, either now or later, that's something, you maybe want to research, is what are the due process violations that I should be looking for? And a conflict of interest is one. And again, this recording will be available, so you could always rewind, write this down, and you'll have a whole list in front of you. Not directly answering the question, lack of notice or opportunity to be heard, all those things. Anything that stops you from having a fair and impartial hearing can be considered a due process violation. So anytime you're being treated unfairly, make note of that and just say it's fair, and it's a breach of fairness and impartiality. So these are things you're going to have to be keen on. And also what I think is helpful is during the proceeding is if you could, as you're making this list, bring this up in the court. Like, look, I'm tracking these due process violations. So far, I've gotten non-responsive answers. I've gotten, threats of contempt for simply asking questions. I'm not being, troublesome. I'm not being disruptive. I'm simply asking a question. If you consider a question disruptive, then then what's fair if you can't, how's that fair if you can't ask questions of evidence? And look, it's not like you're asking a frivolous question. This question is very direct. It's cornerstone of their case, and they're required to have it anyway. So you're not asking for anything that they aren't already supposed to have. All right. So don't let them, conflate it as something that's arcane or something that's just unorthodox or never brought up in court. It may not be brought up in municipal courts, but it's brought up all the time in appellate courts. It's brought up all the time in state courts, in federal courts, on and on. So it's not, and it's something that every attorney has to study, learn, and know going through law school. I mean, so they're tested on this, and not that they actually do know it after decades on the bench, but this is, this is what's going to help you operate more effectively. And so getting back to your worry of, the appeal, if you're effective enough during the initial proceeding or proceedings before you, get railroaded through, you may be able to leave, depending on how effective you are, to stop it from going to an appeal. And maybe they'll offer you a plea bargain, like say, hey, do you want this as, can we amend it to a seatbelt violation or something like that? And at that point, it's you to make a decision,
it's just a parking ticket, just so you know.
Oh, well, then you know what? Go, yeah. Don't a $10 parking ticket, right?
No, it's like 180 because.
That's some spending change. Yeah. Oh, that's some spending change. Okay. Well, right? Yeah. I mean, and is that the maximum fine?
People, that's. I kind of chuckled when I heard that, Jamie. Sorry.
You chuckled when you heard it was handicap?
No, the whole street apparently was handicap parking.
Right, but they only had like 4 signs on like 2 blocks, so we
And
didn't
let me
realize.
guess, over half the handicap spots were empty.
Exactly.
So, I mean, what harm could you have possibly caused anyone who was never even there? I mean, it's that's a state.
Yeah, there's no harm caused. That's right.
Right. I mean, so it's just such a fallacious complaint in so many levels, whether you want to look at the lack of harm, the lack of the authority of them to hear the case, on and on.
Yeah,
It's just, it's them trying to suck money
Another
out of
one
you.
is who's the complaining party. I mean, who have I injured or killed, and where's evidence of this complaining party?
Yeah, I tried to bring that up
Yeah.
at the arraignment, and they just laughed at me. Yeah.
Yeah, those bastards. I mean, come on, you're just asking questions, or you bring up an issue, and they go on the way they
defense. So, I mean, if you have to remind them too. I mean, this is just for my defense. Hello, I'm not a lawyer. I don't understand. I mean, just asking these questions, and you're laughing at me.
do. Well, Keith, I'm thinking,
What's so funny? I mean,
I'm thinking that you're laughing at me, and yet you're trying to extort $180 from me. If before you take my money, at least give me the common courtesy of giving me full discovery, full disclosure. I mean, please, it's other than that. It's rape enough as it is, and it'd still be rape even if they railroad you through. But I mean, come on, at least make it look nice. I mean, public rapings usually never look that great, but I guess when you're in a courtroom, things magically change. So, anyhow, those are some of the core things that I, over listening on during the show and stuff that I think would be. If you get those down core and just get those hardwired in your mind, as far as making objections, knowing why you're asking what you're asking, and tracking due process violations, I think you're going to make it extremely rough for them. It's no guarantee that it's going to, as it's been stated on the show several times, no guarantee that they're actually going to rule in your favor, but you're going to create the conditions that it's, psychologically for them to rule in your favor as opposed to rule against your favor. That's basically how you want to set it up for them is verbally in court say, well, let me get this straight. Let's review here. I've brought up these issues. Your response have been all across the board. We've seen logical fallacies. We've seen, just all these assertions. I haven't gotten a straightforward answer. Evidence is something real simple to articulate. If you're saying that there's a murder weapon, when I ask for evidence of a murder weapon, it shouldn't be too hard to say the knife. It just, it's that evidence should be very, and because a lot of times you say, well, this is so obvious, or it's so given. Well, okay, if it's given, just like the sky's blue at noon, that's given too. I'll accept that. But if I still question it, you could always just simply, you don't even have to speak anything. You point to the sky and say, look, there's your evidence. It's the color blue because it reflects this chemical in the atmosphere, on, and you could have a discussion about it. But when you're asking for evidence of jurisdiction, and they're not so straightforward as you would assume that any question of evidence, would be answered, then, you got something there, and you just have to understand, which logical fallacy are they deploying, which due process violation are they committing. Let's make note of it, and every chance I get, review it in court. So it just makes them look, worse and worse, and harder for them to uphold their facade of legitimacy. And because, of course, when you're in that courtroom, it's not just going to be you and them. It's going to be a courtroom full of people with very similar charges. So they're not going to want to let you go on too far with maybe poking any holes in their legal system without anyone else actually learning what's happening. So if you come across very clear, very concise, and if you convey yourself to the other people in the courtroom and basically give them a template to work off of, that's something that they don't want, and they're likely, at least in my experience, to work with you, whether it be amending it to a lesser violation or completely dismissing it in of itself. I've been offered both, and it just all depends on your communication and how well you convey your points and how how well you could put the ball back in their court, so to speak. I hate to say make them look bad because they do a good enough job of that themselves, but to basically keep that ball in their court and keep them on the defensive and having to, again, and they should be, because whose burden of proof is it yours or theirs?
Right.
So anyhow, I know that's very long-winded, and it's hard to
no, but it helps. It helps because I'm basically being deprogrammed the more I listen,
Sure, and it's not like we're reprogramming with more fictions. We're just taking a look at what actually is. We're taking an objective perspective, an objective look at an objective examination, and then building our narrative, or building our opinions, or building our templates based off of that. So it's you can say you're deprogramming, and I think others would claim that we're reprogramming with more fallacious logic. But I would argue, because I think that everything that we discuss is objective, it's subject to challenge, and any of the critics or anyone who's made those criticisms haven't really come forward and said, where we're wrong or anything like that. And not that we're even, I think that should prove that we're not willing to accept that we could be wrong. We certainly could, but I could look at the sky and see the blue sky. I could look at the green grass, and it doesn't take a doctor just to see things as they are. It's just the hard part is breaking through the conditioning that's already been received. And so anyhow, that's my piece on that. So with that, Vin, do we have you back?
Hello, if you can hear me.
There he is. There it is. Hey, I really want to pass a baton to you here, because I want to get jamming on the podcast and make sure I get that up sooner than later, because the more I get delayed, just the longer it is for me to get back on track here. So, but I did want to just spend some time and go over those just few points that were on my mind from earlier. So I'll let you guys get on. Yeah, no problem. I hope things turn out well for you. And I understand not wanting to go for a $500 appeal. They don't have it that way here in Missouri, but California, Minnesota, ouch. They really stick it to you through the fees. I'm sorry to hear that.
Yeah.
So anyhow, okay. Well, I'll let you guys get to a role play, and don't take it against them if they're if they're rough on you as far as with the questions, because you much rather be tested in here than in the courtroom. With that said, I'll turn it to you guys for a little role play, and anyone of you guys can send me a message privately outside of this chat message if there's anything I need to know, or if you guys are done.
Okay, mate. Are you going to just keep recording it then? You're just going to hop off and do what you got to do?
Yep, that's right. I may or may not be listening, most likely not. But, if I do tune back in, I'll just type a little message in here. I'll be muted up, but I'll type a message and let you know if I pop in or have any input.
Right,
see you, buddy.
Yeah, glad I could join you. Hey, Keith, good talking to you. It's been a while, man.
Nice talking to you too, buddy.
Hey, is it warming up that way, by the way?
Yeah, I had the bike out this afternoon, man.
Yeah, I'm glad to hear it. It's beautiful up here. After this last month, all that freeze and crap that we had.
It's terrible, bud. Terrible.
Yeah, it's nice to be outside or to be able to go outside.
The amount of ice we had with that ice storm, there's just so much ice. Like, it was wild.
Yeah, I'm thinking they should just have the Winter Olympics in North America somewhere, or Canada, because we were suited for it. I remember in Sochi, they said something about it being above freezing and them having a hard time with the snow and ice. Not so much here.
Nope.
So, anyhow, well, good to hear from you guys. I'll talk to you when I talk to you later.
Okay.
Okay, mate. Thanks.
Take care, guys.
Thank you.
See you, Cal.
Right. So, you got to apologise. I've got to apologise. I missed out on part of that because I was rebooting the computer again, so I wasn't sure quite what. Right. So, who wants to play the prosecutor then? I'll play the judge if you like. Apparently, us English types, we play the snotty-nosed judges better. So.
Is there actually a prosecutor, or is it going to be a cop?
It's usually the cop.
It will be a cop. It doesn't say a prosecutor on here, but I would assume there has to be, but I don't know.
Yeah, that's someone there would have thought representing the imaginary state, I suppose. So, yeah. Yeah, well, the first thing you want to go for is obviously they're going to want to start, and as I've already told you, it's objection. I'm not ready to begin yet. So you want to make an issue of the fact that you filed a motion to dismiss, and you want that answer to, and this is where they may adjourn it to an arraignment or a motion hearing.
Right.
So that's the first thing you've got to jump in there to begin with. You've just got to object. You're not ready to start. You want your motion dealt with first.
Okay.
So if I miss something, someone going to jump in there?
Can I jump in there?
Yeah, go on, mate.
Yeah, usually the last time I went in there, it was basically, hello, Mr. or Mrs. Johnny. You've been charged with not producing a license, parking in the handicap space, and not having a license. How do you plead? And we're not here to hear any motions. How do you plead? Yes? No?
Well, I can't plead until I've been that's in the nature and cause of the allegation. So this is why my motion actually needs to be heard first, because I've not actually been fully informed as to the nature of what I'm actually being accused of.
Well, sir,
This
I'm
is Jamie.
informing
This
you right
isn't
now.
rocket science, you know.
Sorry.
Yeah.
Do you plead or guilty or not guilty? That's what I got.
I'm sorry, I'm unable to plead until I've been fully informed as to the nature and cause of the allegations.
Well, sir, we've already informed you of your charges, and so I don't understand why you don't understand about these charges.
I've been accused. However, the accusation does not fully state the nature and cause of the allegations.
Well,
Therefore,
sir,
I want my. So
well,
if you let
sir,
me
the
finish,
nation.
therefore, sorry. If you let me finish, therefore, I do need to have my motion to dismiss addressed, because I don't believe that a valid accusation has been put before this court, or that this court has a justiciable case before it.
Well, sir, the officer pulled you over, and they asked you all these questions. So obviously, you're guilty of that crime, are you not, sir?
Have you already found me guilty before any evidence being put before you by the prosecution?
Or do you,
Well,
do you
we're
understand the charges before you, sir? I might say that.
No,
too.
I don't. See, this is about
What about the charges don't you understand?
What's the nature and cause of the allegations? It's what factually
The ticket. The ticket, sir. The ticket. The
What
handicap
factually is the
parking
ticket? Okay. Well, what factually is the ticket?
Well, the ticket is the complaint made by the officer that you contravened the Motor Vehicle Act, and you're not supposed to park there.
Right. So factually, at this point, it's just a complaint. Is that correct?
It's a complaint with
Yes,
a
sir.
charge, and we're charging you.
Right. So the charge is nothing more than an accusation. Would that be correct?
Yes, we're accusing you of
Right. Is the
violating the
accusation
Motor Vehicle Act.
evidence? Okay. Well, is the accusation evidence of a crime being committed? Yes or no?
Yes, sir. The crime is that
Really?
you violated Motor
An
Vehicle Act.
accusation is evidence of a crime. Is that what you're telling me?
Well, sir, there were other handicapped people that could have parked there, so yes, that's a crime.
Yes. Is that a simple yes or no? An accusation is evidence of a crime. Is that what you say? Is that what you're saying to me?
You got me on that one, Vin.
Listen, Mr.
yes,
I'm
yes,
trying to
yes,
get
sir.
in there. Is yeah.
An
an
This
accusation,
jurisdiction,
not
therefore
evidence of a
you've been charged, therefore the court's moving ahead. We've had enough of your questioning and we're moving ahead. and
the
we're gonna
accusation,
move on.
sir, is the reason
Do
for
I not
your
have
very being here.
Sorry, I didn't quite hear that.
The accusation, sir, is the very reason why you are here, is it not?
I've been accused, absolutely, but is the
Yes,
accusation
that's why you're
evidence
here.
in? Okay, so is the accusation evidence?
I'll
against
tell
my
you-
will, yes,
I'll
under
tell you-
duress, for sure.
I will tell
Yes,
you
sir.
what the accusation is about.
What happens if I
There
didn't
are
show,
certain
sir?
rules. There are certain rules regarding whether or not you can park where you were not supposed to park. That is what is written in statutes, is it not?
Well, I'm not here to argue the merits of their
No,
cases.
it was a rhetorical question, sir. I know that that particular rule exists within our statutes, and you, sir, were seen by one of our officers parked there.
I'm not a lawyer,
As
I
a
don't
result-
understand.
As a result,
I'm not a lawyer, I don't understand.
such and such officer
I'm not a lawyer, I don't understand. Over
had
and
no
over
choice
and over.
but to record said fact upon a piece of paper. The fact being that your car was parked where it shouldn't have been according to statutes. He recorded that fact on a piece of paper.
Okay. I
And
lawyer,
if you
understand
want to
that.
call that an
Legal opinion.
accusation, if you want to call that an accusation, so be it. But nonetheless, we are now dealing with the issue of you having contravened one of our statutes which says you cannot park there. So, how do you...
Okay, well, I understand that that's the
Did you
legal
or did you
opinion.
not park there?
I'm not here to discuss the merits of the case at this point. I need to understand the nature and cause of the allegations being made against
The
me.
nature is...
The judge is going to go off in a second.
Yeah, the nature is that in a minute, if you do not enter a plea, sir, I will have to enter one on your behalf. Would you like me to do that?
Will you be representing me at that point then?
Oh,
No, thank you.
That's a good one. Yeah.
Well, yeah, because what happens is, if they do try to enter a plea on your behalf, they are in effect, they might as well be saying that they are attempting to claim power of attorney over you. And if they do want the power of attorney, they must accept the liability, which means they can no longer ask you questions about anything because you're incompetent. They are in charge of you. They are responsible for you, and they should answer any further questions in regards to the so-called charge instead of you, since they claim power of attorney over you. So they've literally taken away any reason you may ever have had to answer to any charges, since they're the responsible party. So you could actually tell them that. Would you like to be responsible? Because if you want
you
the
don't have
power
to
of
go
attorney, you may have it with all liabilities.
You don't have to go that deep into it. It's just an act of, if they turn around and say, "Well, I'm gonna plea on your behalf," then the simple question is, "Are you now claiming to be representing me? Then are you acting on behalf of me?" And the fact is, all you're saying to him is are you going to give a plea knowing that I'm not fully aware of the nature and cause of the allegations being made against me?
I would probably
because a plea has to be given. A plea has to be made either way, with you understanding fully what you're actually pleading guilty or not guilty to. You have to understand that, and that's written in American law, in their case law. So you have to understand what you're actually being accused of. So you can't plead to anything until you actually know what you're actually being accused of. And saying that you're simply just being accused isn't letting you know what you're actually being accused of.
They want me to plead before the court even started. That was the first thing she says to me. What do you plead, guilty or not guilty? And I'm saying, well, I don't.
So with a parking ticket, if they say to you, "Well, you're being accused of,"
and that's where she turned and said to me, "This isn't rocket science, I says, "Well, I'm not a lawyer. I don't understand, and why should I be given a plea when I haven't even seen, heard the complaint?" So I gave a plea of guilty, and then they changed it midstream and made it not guilty, and it was just the PR bullshit, right?
Yeah. So they can't drag you into court. At least this is their PR. They're not allowed to drag you into court without you understanding what's going on. So the nature and causes, if they turn around to you and say, "Well, you was parked illegally," you say, "What does that make me guilty of?" And they say, "Well, parking illegally. I've had this one, I've asked them, well, speeding. Well, what does speeding make me guilty of?" And they'll just come circular again and just say, "Well, it makes you guilty of speeding." So speeding makes me guilty of speeding, or parking illegally makes you guilty of parking illegally. That's circular, that's nonsense. Parking illegally means you have to be accused of violating somebody's rights, breaching a legal duty, causing a toll, yada, yada, yada. That's what you're being accused of. That's the nature and cause of what you're actually being accused of, essentially.
So they're presuming you to be under that statute, basically.
Yeah.
Right.
Yeah, absolutely. Yeah, if a judge actually says that and says that you're
so
being
you could
accused,
actually ask him, "Are you presuming me to be subservient to this particular statute?"
You were seen. Even if a judge turns around and says you were seen parked illegally, really? Well, that's the opinion. Just it's a fact that your car was on that yellow line, on that road on that day. That's a fact. However, the fact that you're claiming that it's being parked, or the accusation that it was parked illegally, is nothing more than an opinion. So it doesn't matter if your car was there or not. It's an opinion that because it was there, it was illegal. So that's what you have to challenge them on. That's what you have to, come back at them with. That's what they have to answer to.
So in the beginning, this started with you said, I can't plead because I haven't been fully informed of the nature and cause of the allegations.
That's
And then the judge questioned you again, and I said, I do need to have my motion to dismiss heard because I haven't been fully informed of the nature and cause of the allegations. So what do you think they'll ever get back to that sort of chain of argument seemed to get lost about needing to have my motion to dismiss heard?
Yeah, but they can do that. I mean, sometimes they will just adjourn it and they'll say, right, okay, we're going to have a motion hearing, or it may just be adjourned to another day, or they'll turn around and say, well, you're going to trial, we want you to plead. And if the judge pleads on your behalf and drags you in and then says you've got to come back for a trial, that's fine because you can ask for that to be vacated. So it's similar to an appeal, and you can say, no, that wasn't a valid plea. He gave it on my behalf. The judge was trying to represent me. I was trying to make it clear to him that I wasn't fully, I wasn't informed as to, what I was actually trying to plead to, and therefore,
you see, that's why I would
negates the plea.
That's why I would ask the judge, do you wish to be my power of attorney, along with all liabilities that comes with? Your Honour.
That isn't really going to help Jamie. I mean, she's there on Monday. This is along the lines of all the Freeman stuff, that sort of thing. About.
All I'm saying is that a court case got dismissed the second the judge got told, "Do you wish to be my power of attorney, accepting all liabilities that comes with?" And as soon as the judge heard power of attorney, he said, "Get out of my courtroom."
Is my courtroom case dismissed?
I presume so, but they could always bring it back up again. Unless you yourself say this case is dismissed with prejudice. So you have to close the case. If you say, okay, Your Honour, in that case, I declare this case closed. Not dismissed, closed. The case closed. This dismissed bollocks means it can be brought back up again. Okay. So you have to be precise about it's closed. And if he doesn't complain...
This isn't going to help her. This isn't going to help Jamie on Monday. Okay. Going through this sort of stuff. This isn't what she's going to... More than likely that she isn't going to encounter anything like that. The judge is simply going to try and press her to give a plea, or it's going to be a matter of, whether he's going to try and force her into trial or, have it adjourned for a motion hearing. So that's the first thing you go after, is motion. If they're going to push you forward into either making a plea or going to trial, the next point you go after is jurisdiction. What facts is the process, and the standing of the other parties. So,
okay, let's hear that.
So the jurisdiction is basically what facts has the prosecution presented to this court to prove it has jurisdiction.
Right. Let's do it like as if, say you said, I'm not here to argue the merits of the statutes or this case. I need to understand the nature and cause of the allegations, and then. What might the judge say that would make it go to the line of argument of I need the evidence to prove this applies to me?
Well, you've been charged, and you've been accused of this, or you've been charged with this, that, and the other. And you might get a long-winded load of waffle about what section of the act you've allegedly breached and everything else. You were seen on this particular day, those are the facts, yada, yada, yada. That's what you'll get out of them, and it'll be like, right, okay, so, alright, so, yeah, I'm not here to answer to the merits of that just yet. I just want to know what facts has the prosecution presented to this court to prove it has jurisdiction. I need to know that they have standing, that you have a justiciable case before you. So what facts have they presented? And you just keep putting the burden back on them. And if the judge keeps insisting that he has jurisdiction, say That's not based on an arbitrary opinion, is it? And if a judge says no, great, okay, so what is that? So I take it that opinion is based on facts. He says, yes, right, so you can confirm that there's evidence that you have jurisdiction given to you by the prosecutor, and if he says yes, great, give me those facts then. That's basically how you go about doing it. You haven't got to do it as long-winded as that, but it's just a matter of you just keep putting that burden back on them all the time. If the judge refuses to present anything, which you no doubt will, and they just say, we're going ahead with this, you know, we're going to trial, we'll set a date, or they may even try and push you into trial that day, that's usually rarer. It sounds like this is this like an arraignment style?
No, I already had that. This is the trial.
This is the trial. Okay,
Yeah.
so he's going to try and force you into the trial there and then. So,
Right.
well, objection, you just object to every step anyway. Objection, I'm not ready to begin yet. You still have not informed me as to the nature and cause of the allegations. And if you try to say, well, I've already said this, I've already said that, say, no, all you've done is you've read me the accusation. You told me what I'm being accused of. That does not inform me as to the nature and cause. If he says, what do you mean by that? Well, what is this in the nature of? Is this civil or criminal? Now, traffic in America, as far as I'm aware, in all states, is imaginary states, is criminal. So if it's criminal, it'll be in the nature of a public tort. So there has to be the antagonistic assertion of a legal right based on a public tort.
I wonder if she should.
And the cause is you cause the violation of somebody's rights. That is so there you go. So that is the nature and the cause. And they won't tell you that. They'll just say you're being accused of parking illegally. That doesn't tell you anything. But that's what you're trying to get at.
I wonder if she should take in a motion to vacate that plea the judge entered for her. Or against her, I should say.
Yeah, I didn't realise. I thought this was your first hearing. So, yeah, if that's the case and it gets adjourned, the trial gets adjourned, then yeah, that's what you do to, over the plea. So I take it the judge pleaded for you in the last hearing, did they?
No, there was like a judge sitting there in the background, but there was a guy in front, and I'm sorry to say I don't know what his role was or his title, but he was just going through everybody's files, and most of them, had some serious criminal things.
Right.
And then it was my turn, and I had this parking ticket, and that's why he was kind of laughing at me, like, why are you can't argue jurisdiction here. We obviously have jurisdiction, but it was just like at this table right behind the gate, not up on the bench or anything like that, where he was just trying to sort people out. And then he said, fine, you'll go to trial. And that was it.
He didn't ask for a plea or anything, huh?
No, he might have.
And you probably said not guilty?
No, I never said that. So maybe he didn't ask for a plea, because I knew that I could have said, I'll be happy to plead guilty, but that he never even brought that up.
Yeah. So, I mean, it'd be a matter of when you go to trial, they may well ask you to plea and say, well, objection, before we've even started, I was forced into this trial without ever being presented any evidence by the court proving it had jurisdiction to begin with, to force me here to begin with. So, Can you confirm that there is evidence that the court has jurisdiction to force me into this trial? Well, I say to begin with, because I was never given that at the previous hearing. So I need to know that there's actually, this court actually has jurisdiction to even hear this.
Can you guys start that over as a role play? Or do you want me to do it? Okay.
Do you want me to play the judge, or?
I think I'm better right now listening and then trying after that.
Okay.
Yeah.
Right. Who's going to go first then?
What are we looking for?
What did you want to do, Jamie, again? Sorry.
A judge and a defendant and maybe a plaintiff.
Right, okay. What, do you want me to play you, or?
Sure.
Right, okay. So, who's playing the judge? Who wants to play the judge again? Visual, do you want to do it?
Sorry, I was distracted for the last 5 minutes. You'll have to bring me up to speed.
Well, we're just about to start. She's going to trial. So imagine you're the judge and you're about to start it all off.
Has there been a plea already?
No.
No.
We're just about to start. We've just walked in. Imagine that we've gone through all the pomp and procedure of.
And we're still on the same traffic court case, yeah?
Yeah.
Okay. Is the policeman going to be there? No, of course not.
Yeah.
Well, if the police officer isn't there, then the case gets dismissed anyway.
Yeah.
Yeah.
Right.
Well, just imagine he is, and they're going to still try and push it through then. Yeah.
Yeah.
Okay, please stand up. Let's begin. Is so-and-so present? Miss whatever.
Objection, I'm not ready to begin yet.
Right. Would you mind explaining yourself in that case?
Well, I have filed a motion to dismiss that needs addressing, and I am not ready to begin yet, given that the court has not presented any evidence yet at the previous hearing or at this one to show that it has jurisdiction.
Well, this
jurisdiction that must be presented by the prosecution.
Right, well, in order for the prosecution and this whole thing to begin, sir, if you don't mind, we would like to know whether or not you think you're guilty or not. So could you please respond so we may begin and determine all these questions you're interested in?
I'm sorry, but I must object to this. This court has not presented me with any evidence by the prosecution to prove that it has jurisdiction or even hear this case. The previous hearing was rushed through. I was not given the opportunity to establish whether the court had jurisdiction at the previous hearing. So, can you confirm, yes or no, that this court has jurisdiction to hear this case?
Right. You came here of your own accord. You are well aware of the accusation against you. Nobody forced you to
With all due respect,
you responded to the summons. You're here. There is an adjudication to be made, whether you like it or not, and we do require you to plead your case. That is how law works. Okay?
Is that a yes or no?
Would you like to have a lawyer to represent you?
With all due respect,
I would highly
please answer my
suggest
first
you
question.
do. Your first question is invalid, sir. Would you like a lawyer? Because you clearly don't know what you're doing.
With all due respect, I'd just like a straight answer to my question. Yes or no?
Please repeat the question one more time.
Can you confirm
Please repeat the question one more time. Does this court have jurisdiction? Of course it has jurisdiction.
Can you confirm that the court has jurisdiction to hear this case?
I don't need to confirm. You gave us jurisdiction by walking in here.
Do you have facts to prove
so you received the summons. You are well aware of the accusation. You turned up to defend yourself against this accusation. Do you have any questions other than jurisdictional questions? Because obviously, if you're going to talk to me about jurisdiction again, I am either going to lock you up for a few hours or again ask you to get legal advice.
Are you going to
what would it be,
me
sir?
to
Because I'm running out of
to ask a
patience
simple
here.
question?
I'm not going to put up with this in my courtroom. You either plead guilty, get a lawyer, plead not guilty. I don't care which it is, but you're wasting the court's time, and I'm going to find you in contempt of court in a minute.
Well, with all due respect, I'm simply asking a basic question that is allowed to be asked. Jurisdiction can be raised at any time, according to case law.
On your behalf.
Are you now going to be representing me?
And I don't have to. I'm putting this whole hearing forward by 6 months, and you, sir, are expected here in 6 months' time. It is that simple.
Are you representing me and pleading on my behalf?
Case is over, sir. Please find your way outside. You are due here in 6 months' time. I want to hear more out of you. Do not make me get the security to get you out of here. Thank you very much. You can object all you like. You're going out now, and you are due here in 6 months' time. It is that simple. I have put up with enough of your nonsense, sir. I'm not going to have you cause havoc in my courtroom.
Do you have a senior judge here, sir, I could speak to?
Right, somebody go and get security now, please. Right, that's as well.
You really think it'd go that way?
No, of course not, but we're playing the worst of the worst.
Oh, God.
I can get that bad, but the thing is just back off a little bit. Yeah.
I mean,
what was the last thing you said, Vin, when you said, "Can I talk to a what judge?"
Is there a more senior judge than you that I could speak to here?
Yeah, can I talk to your supervisor? Okay.
What's he gonna say? Yeah, sure. Let me go and fetch him. No, he's gonna try and talk over you, of course.
I tell you the name. I mean, I had it. They told me the name. Yeah, Judge Southern. Like, right, I'm going to find him. Where's his office? Yeah, I mean, that's what I did. So, you know, you can do it that way, but that's the thing. You've got to tease them. If you know they're going to get violent, then fair enough, back off and let them act that way, because then it's just a matter of, all right, fine, let this go to appeal. And if they're going to adjourn it, fine, you've got 6 months to then, you know, put an appeal in and everything else. And the way to look at it, the way what I was trying to explain to you before was, and Calvin probably went over this hopefully, but it's because none of us are guaranteed a fair hearing. We know we're not going to get it. So the next step is to lay a platform for an appeal. So the more questions you get in there, and the more you get them out of their pram and throwing the dummies, the more grounds you have for appeal. So you're not just throwing one issue at them, i.e. jurisdiction or applicability of the law. You're throwing everything at them, because you'll usually be able to bring up the issue of jurisdiction. They've never been able to produce any facts proving jurisdiction, no facts proving applicability of the law, no witness or cop with first-hand personal knowledge, and no presumption of innocence. And that's going to be gone. And then, obviously, if you're forced into trial and they force you to have to cross-examine a copper, they'll probably deny your cross-examination after you've asked the first 2 questions. It'll be
the first 2 questions just to the judge about asking to hear my motion.
Yeah.
Right.
If they're going to deny you a motion or give you or not address the motion properly and give you a valid reason for denying it, that again counts against them. So they may well say, when you turn and say, I've got a motion here that I want to I want to have answered to. You know, I've asked for this case to be dismissed, and the grounds are in my motion. If they deny the motion and won't give you a proper reason why, which they never do, that goes against them again. So again, you're setting grounds for appeal.
What if they say, well, we're not going to hear your motion because we didn't have enough time to consider it?
Is there a time limit on when you got to put motions in?
Well, it doesn't say it on my order to appear.
Okay. Well, I mean, it doesn't matter, even if they say, well, you should have put this motion in earlier. It doesn't change the fact that they still, on the day, have to produce facts proving jurisdiction and everything.
Okay.
So the grounds you're going to raise in the motion are still grounds that you can raise on the day anyway. And they've got to have those facts to actually bring a valid case against you. So don't worry about that so much. It's just a fact of, if they won't listen to it or won't give you grounds why and deny it, that all counts against them as an appeal. So you may end up getting fined still. Let's say they convict you anyway, you get fined and you might get a $300 or $400 fine. If it's £500 to put the appeal through, well then sometimes there are ways, I think, where you be able to put an appeal through where you don't have to pay for it. Because usually with criminal, you don't pay for an appeal. But again, if the decision they made was flawed anyway, you still may be able to appeal it. You may be forced to pay it first, but then you may find grounds to be able to appeal it without it costing you, and that way you'll get your money back plus costs anyway. So this is what you're trying to do for yourself. You're guaranteed not to get a fair hearing, so you're trying to lay a platform where you've got solid grounds for appeal, and you've got more than one issue you can raise with them on appeal.
Okay.
And like I say, all the issues that we raise will be issues for appeal more than likely. I mean, the fact that there's a conflict of interest, who does a cop represent? The state. Who does a judge work for? The state. Straight away.
Yeah, there was one thing I thought of today when I rode my bike home. I passed my neighbor standing outside who's a prosecutor, and I could just imagine that she would be there, and that should be a conflict of interest.
Yeah. Yeah. But,
I mean, chances are it wouldn't be her, but it just occurred to me.
Yeah, but it's a weird world they live in, because the way they look at it is they have to be able to argue both sides to any case with equal passion. So it just goes to prove it's got nothing to do with them getting to the truth. It's to do with who can argue the best. So you're going in there with you're going in there basically just trying to be rational. So you're not arguing. You just want to be rational. You just want to be given the facts. They're going to want to argue, just to turn the case. They just want to win. They couldn't care less about the truth. They just want to win their case, and they'll do whatever it takes to win that case, even if their reasoning and the rationality behind it is completely flawed. They just want to win their case, and that's what you're ultimately exposing. You don't have to be a lawyer and argue. You don't have to take a side. The only side you're on is truth. You just want to go in there and be rational. You explain this to me as from a rational point of view and not a legal one, because they're lawyers. Yeah, these people you're in front of, just because they've studied law and got degrees and all that, doesn't give them monopoly. Doesn't give them the monopoly over logic and reason. Logic and reason exists irrespective of their education, and it trumps any legal education, regardless of what they think they know and what they understand about their so-called opinions. Their laws is irrelevant compared to the fact that however they put it across, it's got to be rational and logical, and that is an independent set of principles, regardless of their legal training. So that's the way to look at it. Does that help, or did I go over the top?
Yeah. No, it helps.
But that's why, being rational and being logical trumps any of that. So, so long as you can stay focused. Concepts in somebody's head. That's not real. There is no real victim. The victim is imaginary. And that's who... I think Kelvin is back with us.
Yeah, just Calvin. Oh no, there's 4 of us.
Hey guys, did something happen with the call, or was it just me?
Yeah, no, it dropped off. We lost the call. Oh, there we go. Jamie's back.
Wow. Okay, so you guys all lost it then, right?
Yeah.
Yeah, we all lost it that time. Yeah.
That's strange. I mean, so did I. It was almost as if my internet connection was disconnected, yet my networking icon is fine, and it wasn't letting me browse through my browser too well for just a minute there, but then it just kind of kicked back on, so who knows what that's about.
Yeah, I suppose I was getting too impressive. The NSA cut us off again.
Yeah, that's right. You just can't have too much effective damage control in one session. I think we only have like a 15-minute time limit before someone wants to start knocking the connections.
Yeah, we had that once, didn't we, when we was on a call. It was about 5 minutes. The conversation just started to get juicy, and then they cut us off straight away.
Yeah, that's bizarre. I mean, yeah, mine kind of went berserk. So, anyhow, yeah, I just went and got a bite to eat and came back and noticed everything was disconnected. So, all right, guys. Well, I'll let you. Mark, how's everything going so far? Gotten any good role playing?
I've been
A little
listening.
bit.
I've listened to 2 role plays where they've been being me, which is still helpful to me.
Well, good.
Yeah.
Yeah, sometimes that helps because you can put yourself in their place then, can't you?
Yeah.
In that respect, so it does help because you're trying to think of what to say when you're there. But usually when you're there on the day, it flows a little bit more smoother, and sometimes you find that you're being rushed through. So you start sort of panicking a little. Well, not panicking, but you feel a little bit overwhelmed by it sometimes, and you feel like you're being rushed. So you can forget to say certain things and all that. So, but don't worry about that. It's just a matter, as long as you at least get the first few main questions in, you're giving yourself, like I say, the chance of having it overturned, even if ultimately you get convicted later on down the line. So that's the thing. That's what we're trying to do. We're trying to set that platform to get it overturned on appeal, because we know this. You're never going to be guaranteed to get a fair, And this is.
So
this is
I noticed
generally
nobody said. I guess because we were trying to get them not to start the trial, nobody said that line. Am I guaranteed a fair hearing?
Yeah, I mean, it usually starts off with that. That's once you've got past the jurisdiction and the
Right. Okay.
And the conflicts of interest stuff. So you get your first lot of questions in there in that respect, but you usually bring jurisdiction up in your motion to dismiss first. So it's usually.
Yeah.
I mean, what do you normally do, Calvin? Do you sort of go for jurisdiction first, or do you go for the motion first?
Well, I go for the motion first because, of course, the first thing you do before even making an appearance is you file that motion to dismiss. And then for the arraignment, you unsigned plea of guilt, but you could go either one or two ways with that. You say, I have some questions, and go straight into the script and whatever you want to get in and ask them, and that's start an arraignment. Or you could say, hey, I have a motion filed. Before I can enter a plea, could I get a ruling on this motions hearing and schedule this for...
I'm pretty sure the arraignment already happened.
Okay, this is your second appearance then?
Yeah, the first one was about 1 minute.
Oh, okay. Well, how did that end up? Did you have the paperwork
that
filed
ended
then?
up with him just laughing at me and saying, oh, you're going to try and argue jurisdiction.
That's right.
Well, that's not even a question. Jeez. And it wasn't a judge that I know of. It was just somebody standing kind of below the bench in front of the gate.
Oh, that's interesting. So it's maybe one of the court clerks?
Yeah.
Right.
Well, they're not the judge, so no matter what they say, the judge is the judge. Like, I know what they're doing. They're saying it based on their experience. The judge isn't going to allow you to get in this issue, but that... They're just speaking from their, I've had cops come up to me and tell me, don't do this, don't do that. And, I more or less just ignore it. It's not until the judge tells me to do something that I, even consider it. There was a time when I was in court and I was questioning the judge, and the judge really he had a hard time answering, but the cops knew that, and they saw the judge in a hot seat. And it's because I kept asking the same question. I kept going back to the original question. It was never answered. And the cop came up and he said, hey, you can't ask those questions here. If you ask them, we're going to kick you out of court. And I looked at him, I let him finish what he was saying, and I just kept right back on, because the judge never said, I'm not going to answer this question. He never said not to answer it, or not to ask it. So, you're going to have your problems with that. So this is your second hearing. You've already, for your arraignment, have you pled not guilty, or how did that go? Did they put a plea in on your behalf?
Not that I know of.
Okay, so you haven't even entered a plea then. Okay.
Right.
This second hearing, is this just a continuance maybe from the first one?
It just
I mean, when you were there, did they tell you
As far
they're
as I
going
know,
to?
that was the arraignment, and this is the report. I mean, this is the trial. It says order to report.
Okay, well, if this is the
Scheduled
trial,
for court trial.
all right. If this is the trial, what they did is they went ahead and, of course, committed a new due process violation, and they put in a plea on your behalf because you didn't plead not guilty, right?
Right.
Okay, so they pled on your behalf, which is kind of breaking the conflict, or well, it's a conflict of interest because how can they represent you and then you have a fair hearing if they're representing you? So there's one thing that you can put on your list of due process violations, and a trial. Wow, a trial. With this, before this goes to a hearing, I mean, considering there's a motion pending, it should have been set up for a motions hearing, which is just basically it's another appearance, but instead of there being a trial, you get to have your motion argued and discussed and ruled on, and then from there, then you schedule a trial if, let's say, you don't get the case dismissed. So what you should be going in, not that I understand it is a trial, but it should have been a motions hearing. If there's any way while you're in court to tell the judge, because you haven't seen the judge yet, have you?
No.
Okay. So this is bizarre, by the way. I mean, even for municipal standards, but when you see the judge, you can request, say, hey, judge, I haven't had an opportunity to request, and I just don't know where to go for this, but I need to have a motions hearing. I have a motion filed. I'm not prepared for trial. Just like, Mark said, are you prepared to proceed? No, hell no. I mean, I have a motion I need ruled on, and I'm just not ready for trial. There's still discovery, and that's a big one right there. You haven't had an opportunity to sit down for disclosure and for the prosecution to disclose whatever facts they have or whatever they're going to any evidence that they have that they're going to use against you. So I mean, you're certainly not ready for on almost every level, and so you should be able to stop that. Hopefully, you can. If not, you're going to have to do the best with what you got, and go on with the questions. Is there any evidence? And of course, they're not going to be able to provide any evidence. So the entire time, whether they cover it up or not, or stop you from asking the question or not, you're going to have to, keep repeating on the record that there has been no evidence supported other than just circular logic of referring back to the law to derive evidence of jurisdiction or geographic location, which doesn't, just because you are somewhere, again, going back to the church analogy, just because you live within a diocese of a particular Catholic church doesn't necessarily mean that their laws or their doctrine applies to you. Obviously, everyone gets that. Well, same should go for the state. What makes them any more privileged, or what has given them any more or any legitimate authority over you? Because with a church, by association, you can say, well, yeah, I signed up for the church. Here's my registration. Here's, where I said that, I would agree and abide by their laws. You don't have any of that when it comes to the state. So when you ask for applicability of their laws, if they're not providing any evidence, any form of a contract or, and a valid contract at that, if they say the driver's license is a contract, no, it's not. It's a document that's obtained under threat, duress, or coercion. If you weren't threatened to have a driver's license, if it was actually optional, most people wouldn't have it, including, I'm going to go and speak for yourself, but including yourself. It's something we all have to do. It's a mandatory thing. So it's, hopefully you could go in there and be able to get a motions hearing scheduled and get this taken off a trial setting. And it's happened. It's been done before. And usually, I mean, it's just a simple request and the judge says, okay, yep, we'll reschedule this, no problem. Because it's no sweat off their back. They don't have to go, put in 4 hours worth of work to reschedule. It's just a matter of them whipping the pen and giving you a new date. So it's not difficult for them. But where the reluctance will be is that they don't want to address the issues that you're bringing up. Presumably, you haven't met them yet, but, if experience is any guide, they're not going to want to get into the issues that you want to challenge. And so you're going to, of course, there's going to be some resistance there. But the request in of itself is very simple. It's generally granted to any lawyer, and it should be granted any, first-time pro se litigant such as yourself. Right. In accordance with fairness and impartiality, but that doesn't necessarily mean to expect that, and also to be prepared, for the worst, that if they deny that you may, end up in a trial. And I guess, it's a $180 ticket, so, you're going to be out $180, but you're really, as you'll find out, the experience is unparalleled, because it's one thing to know that the system's a sham just by logically thinking about it, but to go through it and expect some level of consistency from these bureaucrats, because of course they're the ones who ride the moral high horse, saying that, they're just, they're legitimate, they have the authority that they have, that's their claim, and all you're doing is challenging it. So, it's another thing to go in and experience them just completely being unjust, illegitimate, and just in evil in almost every way. It really, I think if more people had that experience, we wouldn't really have the fake debate issues that we have in these, in the political environment we have now. It'd be real issues like, what are these guys doing with this, let's say the drug war, for example, or even traffic citations, like outside, how many citations are issued where there's just no victim? It's just hypothetical, but the whole legal system is built to only address real harm or damage that's been done to real victims. So they're completely taking something that's meant to protect people in case something happens and flipping it around and making it a whole protection racket where all they can do all day is just give out traffic citations. And for the most part, because so many people comply, they're going to get their extortion fees, and it's a multi-billion-dollar problem. It's it kind of, you've heard the thing, if one person kills somebody, it's murder. If one person kills 10,000 people, it's a statistic. Same goes with extortion. If one person steals from one person, well, that person's a thief, okay? And no one has a problem calling a thief, but when a group of people, 535 men and women, steal from 350 million people, it's not theft, it's taxation. And that goes back to the the conditioning, the programming that we all get in schools, and what we're made to accept. And part of it's a school, but most of it's really just conformity, just like speech. You learn how to talk from emulating other people by kind of conforming to their communication patterns. And so too with fictional ideas that we use for some sort of social organization, if you could even call it that. But of course that's the intention, social order. But of course, all it really perpetuates is social disorder, chaos, destruction, and theft. So it's really going and correcting that wrong that with those who have eyes to see care to do anything about. It's part of what's going on when you're going into court, especially with the questions that you're asking now. I got to say, Jamie, too, are you? I hope. I mean, if let me put it like this: if you're just trying to get out of this situation with expending the least amount of money as possible, I wouldn't recommend.
No, I consider it tuition.
Okay, great. And you know what? And I do too. I've been to court more than a dozen times.
The issue is, for me to spend $500 to go to appeals court, that's going to be a lot of justifying with my husband, who's English, by the way.
Oh, okay. From across the pond, huh? So there's a lot of UK here. I mean, I think I'm the only, you and I are the only Native American, well, if we could call ourselves Native Americans, God, what we did to them. But our forefathers, I guess. Wow, so we're all just a bunch of mutts here.
Yeah. But if you get it back after you win in appeals court, then at least it's a worthwhile gamble,
Sure, absolutely. And there's a good chance, because the better of a job you do documenting the damages and harm and their due process violations, the easier of a case you make it for an appellate judge to rule in your favor. And that's if you're going through a railroading, that's what you got to keep in mind. It's just, what can I do with the limited time I have, the very short limited time I have, to make a case for the judge above this person to look at the situation and say, obviously, due process violation here. It's irreversible, and we have to dismiss it. So that's what we want to keep in mind, is how can I make the best case for an appellate judge to reverse this and award costs. So at this point, I don't start arguing, hey, I didn't plead, they filed a plea for me. I would bring that up, as a matter of fact, because that is a big initial due process violation. And it's a big one. So it's the first big one they committed. Your plea is supposed to be voluntary and only on your behalf. And they should ask you, and I know they do in Missouri courts, I guess I suppose they don't do here, but they'll ask you before they convict you, was your plea coerced, or if you enter a plea, like if you say I'm guilty, I want to plead guilty, or I want to plead not guilty, they should ask you, is your plea coerced, or was it given of free will? And so, you know, it is an issue that it's not coerced, and obviously, in here in this case, it was. You know, they did it on your behalf, and you know, truth be damned, or your opinion or your plea from your behalf be damned. So, yeah, it's a big issue. I would bring that up and say, you know, because I didn't get a proper plea proceeding, could we at least take this motion that I have filed, and can I at least have this scheduled for a motions hearing where we can hear the issues before having to go straight to trial? Because I can tell you right now, I don't have full disclosure. I mean, and you don't, Jamie, you don't have all the, you know, you have questions of evidence of jurisdiction that haven't been answered and haven't been produced for you that you're, you know, waiting so you can defend yourself. Because if it comes out through the discovery process that they have jurisdiction, then that's the information needed to do to decide on how to plea. Now, if it comes out that if they can't produce evidence of jurisdiction, then just like any case where you can't produce required evidence, then you can properly defend yourself. You know, instead of putting a plea of guilt, if they do prove it, if they can't prove it, then you're going to move to dismiss. So that's the importance of having all the information in front of you, because what it's going to do is it's going to guide how you're going to proceed forward. And without that information, you simply can't make a decision on which way to go. So you haven't had full disclosure. You need full disclosure, and going straight to trial isn't going to get you there. You, at the very least, need a motions hearing, and at the very most, just have it reset back to the arraignment setting and go from there. But they're likely not to grant that. More than likely, what they will do if you request it is give you a motions hearing where you can, you know, go through the motion, say, all right, if the prosecutor has this, then he'll answer, yes, I have it, and I won't even ask what, you know, I don't know if I'd say this, but I would say I won't even ask what it is. But if he says he actually has evidence, but of course you want to know exactly what it is, because when he says yes, he's going to probably throw out a logical fallacy. So you're always going to want to follow up with what is that evidence to make sure it's not anything like, oh, well, it's a statute, or, you know, something circular like that. But, you know, if the prosecutor has evidence, then, you know, I'd like to plea and make this short and sweet and not have to waste anybody's time and money. And if there isn't evidence, then I would, you know, look, I've spent this amount of money, you know, and if it's an appeal, you know, I spent $500, wasn't cheap. And, you know, in the name of justice, I think I should at least be awarded my expenses, at the very least, if not, you know, compensated, for lost work and other things. So, yeah, that's what I do. I definitely ask about,
So the fact that I didn't get discovery or didn't have any facts disclosed, they can't. I mean, I want to know it so I can be solid in that.
Sure. Yes.
For that.
Absolutely.
Couldn't they just say, well, you've known there was a trial for 3 months and you could have asked for discovery that whole time?
Well, I'm not a lawyer. I don't understand the processes of the court. You people forced me here against my will. How am I meant to understand what the process is?
Okay.
That's what it comes down to.
And the thing is, it's just because you had the amount of time, you didn't know exactly how to go about getting discovery. You know, I mean, and the instruments, the processes that are available for discovery, such as depositions, discovery hearings, or motion hearings, those have all not one of those have taken place. So you haven't had a proper venue to receive discovery. So just because they say that you've had 3 weeks or months or whatever, doesn't, I mean, they are the ones who forced you into a trial. You know, that wasn't by your request. You didn't even plea for it. So it, you know, I could understand how that's a little confusing and a lot to work through to be able to get to the point to where you can properly request discovery. So I would say something along those lines. Does that make sense?
If you get the same,
yeah.
Sorry, I was going to say, if you get the same sort of attitude from them where they start laughing at you over why you're challenging a parking ticket, it's a matter of saying to them, well, if you people are so cocksure of your case against me, why have you bothered bringing me to court? Because you're taking the attitude that you don't need to prove anything. So why am I in court? If the case you've got against me is so rock solid, I don't need to be here then, do I? Just find me and that's it. Because as far as you people are concerned, you've already convicted me. You've got a rock solid case against me. You've got nothing to prove. Well, there's no reason for me to be in court then. The whole reason you're meant to be dragged in court is for them to prove their case. And if they're taking the attitude of how dare you challenge us, and what makes you think you can beat this, well, then it comes back to the fact of, well, if that's the case, well, then why bring someone to court in the first place? Your attitude is you've nothing to prove.
Right.
You got an airtight case against me.
That's very good,
So
James, and it's always good to kind of put in put in English or in simple terms what actually is going on, because all of their language is wrapped up in legalese. So you'll hear Mark do this, and Vin was kind of pointing the same thing out, is that you want to explain the situation for what's actually happening. You know, you're not giving me a full discovery. You're just moving forward. There's no fairness. There's no impartiality. You know, is that what's happening here? Because it seems like every step of the way I've been forced. I haven't received my due process and my notice and opportunity to be heard. So, you know, by putting things in very simple terms and just rewording them into what's actually happening, as opposed to their legalese version of how they want to say things are happening, like, you know, is very powerful into kind of getting what you want. Because when you put it back in layman's terms, you know, you got the whole group of people behind you understanding that and looking at the judge like, well, yeah, that we're interested, you know, and, you know, the judge isn't going to compromise his perceived legitimacy amongst the sheep who are just there to get fleeced, just to cater to someone who's actually challenging them. You know, you want to create the situation where the easiest thing for them to do is just to dismiss the ticket and get you out of there. And they may make up some stupid reason, like, you know, you have a trial. Maybe if you're lucky, the cop doesn't show up. And that, along with the questions that you're asking, is going to give them the conditions just for them to easily say, oh, well, the cop isn't here, so we'll, you know, toss this case out of court. As has happened many times, you know, if you go through the success story section on Mark's site. So you could have a situation like that. So it's just one of those things where you want to keep all eyes open, you know, all ears open, and just kind of see what the conditions are when you're there.
In most likelihood, the copper won't turn up, and you'll be able to, you know, have the case dismissed on the fact that we haven't got any witnesses or first-hand personal knowledge to present the case. So I'm going to ask for this to be dismissed.
That's a huge one. Yeah, you guys have been doing good on that one, Vin. I haven't had very much luck here with that, but you guys are knocking it out of the park. You know, that's just not my area of expertise when I go in there, and I wouldn't say I'm an expert in any. I'm not a lawyer. I'm not, you know, anything like that. But that's just not anything I'm too sharp with. You know, that's not my sharpest points. But you guys really, the qualifications of the witness to give the legal opinion to prove jurisdiction, bam, you guys got that down great, and have gotten some great results with asking that question.
That's it. Yeah. I mean, it's. I mean, say else when you're in court, you can turn around and say to them, "Look, I'm not being prosecuted arbitrarily here, am I?" They say no. Great. So you say that you know, I'm being accused under this statute. You're not trying to make the facts fit the statute, are you? If I say no, say great. So you've got facts independent of that statute proving that it applies to me. Can you confirm that? You know, and you sort of go, you know, and these are the sort of questions you want to. You know, obviously you've only got this weekend to get yourself prepared, but you know, this is where you're taking it, and the thing to understand with facts is your opinion has to conform to reality. It can't work the other way round for it to be for it to be rational, obviously. So you can't make the facts fit the opinion that you have that act applies, just because you say so, or just because the act exists. You have to have facts outside of that, independent of that statute, to prove it applies to somebody. But they always try and make the facts fit the opinion. You get me?
So you said, I'm not being prosecuted arbitrarily, am I? And then they say no, and then what was the one after that? It was, so the statute isn't the proof that I'm being, it was something like that.
Yeah, so if they bring up the statute and say, you know, I'm being accused of breaching this statute allegedly, so you say to them, right, so therefore you have facts independent of that statute to prove that it applies.
That's beautiful, Vin. I got to say, I just got to chime in. That's beautiful. I mean, I really admire that. That's a good one too. Really, I mean, that's within 3 questions, you really have them backed into a corner that they can't get out of because there are no facts beyond the statutes that they can produce to prove anything. Very beautiful.
That's it. But yeah, it gets that simple. And once you start to learn the logic of it, once you start to get your head wraps around actually doing this in a rational way, that sort of makes sense. And like I was saying before, I don't know if we got cut off when I was talking to you before about this, but walking in there and doing this in a rational way, a rational and a logical way, trumps any legal education. It doesn't matter how well they think they understand their processes and laws and all that. Unless it's rational, it means absolutely nothing. So that will trump any other type of education they think they've got. If they think they've got an advantage over you because they're legally trained, well, it makes absolutely no difference when it's put up against, logic and rationality.
And what validates exactly what Jim's saying.
They don't have a monopoly on logic and rationality just because they're lawyers. And if they start getting arsy with you in that sense, and I've done this with me in court, and I've said it, you people think just because you're lawyers, you have a monopoly on logic and rationality.
And that's true.
And they'll go, no, right.
And then I got to say, I point out that you do a great job in committing them to taking one position on that when you ask that very first question. Are these arbitrary? Because once they say that these aren't arbitrary proceedings and charges, then they only have rationality. And if they can't produce a rationality to connect all the dots, then what they're doing is they're reneging on their first answer, and it is arbitrary. It's just that they don't understand, they can't think to, the 2 or 3 questions down from where you're going to get, end up to understand that the first answer to that question really puts them, it takes away any backdoor they have. Legal backdoor, that is, because after that, it's all based on facts. So, I mean, I got to say
sometimes they'll say to you, well, what do you mean by facts? Sometimes they throw that back at you and they'll go, what do you mean by facts then? They think just because a statute exists or that they have an opinion that a statute applies to you.
Law equals legal opinion.
Therefore, that it does. So, yeah. So this is where you've got to come at them and say, well, a fact is a measured and, it's a measurable body of knowledge that is non-contradictory.
Right.
That's basically what a fact is.
Wow, that's an impressive definition there too. Yeah, I don't know if I can go that deep. That's great.
Yeah, but that's ultimately truth has no contradiction. You just want to get to the truth,
right?
So a fact or a model, it's like what we use with this line of questioning, the Socratic model of questioning. It's a model. It's a measurable model that you can demonstrate and show. It gets you to the truth. It gets you there. It gets you to a point where you can't contradict what's being said. And it's like when we talk about law and we say laws an opinion. Well, how can we show a model, a working model, to prove that law is just an opinion? Well, all you do is you just simply take it back to its source. Where does it come from? Where does law come from? And even the courts admit this. Law, let's call it a statute. A statute. Well, a statute is a written instrument, and a written instrument is a written will and opinion of the legislator. It's somebody's opinion of a group of people who call themselves either judges or legislators or lawyers. That's it. So we can trace it back straight to its source, where it came from, and prove it. And nobody can contradict that. Nobody can say that laws are burning bush on a mountain somewhere and it barks laws at us. It tells us what we can and can't do. It doesn't work that way, But and like I say, so that's a workable model. If you really wanted to get anal about it, that's what you could do. You could trace it back. So that's what we mean when you're tracing a fact back. You're ultimately tracing it back to its source, because anything that's a fact is ultimately measurable. You can take it back to its beginning, and that's what you want to do. So when they're saying a statute applies to you, well, factually you have to know what the statute is, what created it, where its source is, and then you move from there. You move from its beginnings and bring it to its ultimate conclusion. And if it's just an opinion and they can't prove that opinion applies to you in any way, shape or form, well then all it remains is just an opinion. And it's a baseless opinion at that. Because it can't be proven to apply to anybody. Just because you can stick a gun to someone's head and force that opinion on somebody doesn't make it, isn't a rationale or a justification to make that a fact. to make that true. Just because you can do something is different to justifying it.
Can I ask one more question about the Monday before I go eat dinner?
Sure, yeah.
I'm just reimagining the whole thing. They start off, they say, okay, you know, approach the Jamie Verdane, you know.
Mm-hmm.
I don't know what they say right when they begin, and then I say, objection, I'm not ready for trial. Would you think I should start out with because I didn't file the plea and they plead for me, or because I filed this motion to dismiss and I haven't had a chance to have that motion heard?
I would say primarily use that they forced the plea upon you, but
Okay.
secondarily as a second reason also that you have a pending motion that you would like ruled on before you guys actually get to trial, because again, depending on the decision of the motion, you may not have to go to trial, therefore saving money for the court and for the defendant and for all parties really.
Right.
Or, you know, based on decision, you will make it a decision to plead guilty, perhaps, you know, in their best case scenario for them. So, yeah, I would use both of them, but start off with the plea was forced. It wasn't a plea that you submitted yourself. And then also, if you need to, mention the pending motions and at least move for a motions hearing.
Okay.
I would just say, objection. I'm not ready to begin. I've not been informed as to the nature and cause of these allegations yet. Plus, I have a motion to dismiss that I need dealing with, and you go from there. And they may move straight onto the motion and say, "Well, I'm going to dismiss it. It's frivolous. It's it's got nothing to do with this case." Whatever excuse they'll make, as soon as they start that, say, "Well, can you please tell me what's wrong with it? Please point out the section or the issues that you claim are either not relevant here or are frivolous or whatever." And you want to get them to actually commit to pointing to specifically to something that's written in that motion that they claim doesn't apply there, you know, or you know, grounds for why they want to dismiss it. So that's what you just simply want to push them on. Give me a rational explanation as to why you won't accept this.
Okay.
Because what you're doing with the application to dismiss is you're giving them their opinions back at them. You're not giving an opinion yourself. All you're laying out is that the facts that they haven't filed a valid claim, and that's based on the opinions that they have in the case law that says to have a valid case before a court you have to have A, B and C. A, B and C is not in this complaint, therefore, you know, this is why this case should be dismissed. So you're basing that on the fact that this is what they say should be a justiciable case before them, and you clearly haven't got it. So, what I say, in order for them to dig their way out of that, they've got to give you a rational explanation as to why they're not going to accept it. So that's an issue you push them on right from the start as well. So straight away it's an issue of jurisdiction. They'll usually dismiss the application to dismiss, but they'll do it without giving you a rational reason why, or valid grounds why. So that's two issues against them straight away. If they're going to do that as well, the presumption of innocence is gone straight away. So 3 things. Then there'll be the issue of the conflict of interest. There'll be no facts proving applicability of the law. So just within the first 10 minutes, you've probably got about 6 or 7 issues against them. Things that are, due process procedures, issues that they're meant to be following, and they're just going to ignore it straight away.
Okay. Okay, thank you guys.
It's being recorded and you can sort of catch up on this anyway. But if you
I
want
will
to do
definitely, if I want to do what?
If you want to do another one tomorrow, let us know. Get back to us Sunday, and we'll try and set up another one, or I'll just get together with you, just me and you, if you like, and
that sounds great.
I'll help talk through it a bit more. But yeah, we'll try and get another court role play session set up Sunday.
Okay.
And you just get used to answering tough questions too, and just being, basically being psychologically abused, because that's exactly what's going to happen in the court. They're going to completely disrespect and disregard every legitimate request you have, and they're going to do it in the most evil, rude way possible. And so just expect to be offended and to be just completely abused. And that's certainly exactly what it is. I know they like to pretty it up as they're just, it's the proceedings, the order of the proceeding, whatever. No, it's not. It's them being dicks because they can, and not giving a crap. The complete lack of empathy, and it's completely uncalled for. It's unprovoked, and it's unjust. They don't have any evidence. They don't have any legitimacy over the hearings. And all they're trying to do the entire time is just, maintain a facade, basically, for everyone else. Because I'm sure after a few questions, they're going to lose hope on you. They're not going to be worried about making sure that you toe the line. What they're going to be concerned with is the other people in the room, and possibly the media reps that you bring in who are going to witness this stuff, and also will be reporting on it on a public forum, on a national radio show. So. Those are things you could kind of use in your favor. But I would take Jim up on the role playing tomorrow, and beyond that as well. Try and get in contact with Mark Monday before your hearing. For any refreshers, any loose gaps, final questions before you have to waltz on in there and sing their song and dance or dance.
Well, I've been dealing with TSA for like 7 times in the last week, so.
I'm sorry to hear that. Jeez. All right. Well, yeah. All right. There we go. So.
That was practice.
Yeah, they've broken you, as it said. Oh well. Yeah, I'm sorry to hear that. That's not even good news, but maybe you'll be a little bit more prepared.
Jamie, I've just sent you a book through a PDF.
Oh, great.
So if you want to download that, that's on logical fallacies. So if you get the time to look through it, it's a book that lists about 300 logical fallacies, and just get used to a few of the most common ones that you'll come across.
I haven't seen that book, Vin, but why don't you give her some of the top ones that come out in court, just so she knows what to look for? Because, like Mark said, the more you're familiar with it.
The main one will be circular logic. It'll be the law applies because the law says so and all this sort of thing. So that's circular logic. That's called begging the question. The other one that you may get, because you're asking for evidence that the law applies, the statute applies, they'll turn around and say, oh, so you think the law doesn't apply to you then? Is that what you're saying? That's called a straw man attack. And sometimes what you'll get is the prosecution. We get it in this country. I don't know how it works in the American courts so much, but the prosecution will stand up and say, well, the accused is trying, therefore, to claim that the law doesn't apply to them. They think they're special and all that. Jump up straight away, objection, that's a straw man fallacy. You're totally misrepresenting what I'm asking for. I'm asking for facts proving the law applies. I'm not saying a word about claiming that the law doesn't apply to me, or I think I'm special, or some sort of argument like that. I'm not raising an argument. I'm not taking a position. He's totally misrepresenting what I'm asking for. I'm asking for facts.
Any chance you could post that book in the main room so I could read it as well?
Sure, yeah. I think that's maybe why the room's having aggro.
And if you remember from a few shows back, Mark pointed out another big logical fallacy: speculation. Because of course there's going to be a lot of speculation that the laws apply or how they apply. Especially with what Vin was talking about earlier with the witnesses. They speculate that and they've made the determination based on speculation that the laws apply because they said so, or because the lawyer says so, or because the department's okayed it for us to operate in this manner. But it's not. It's just pure speculations. You heard from somebody else, or it's not anything that you've proven or seen proof or evidence of. It's just, it's the assumption of the day, and it's very speculative. So that's another big one. But there's,
I think if they come out of anything such as the law applies to you, or that you was in the state at the time of this offence, and yada yada yada, say objection, assuming facts not in evidence. Where are the facts to prove that law applies, or where are the facts to prove I was physically within the state?
There you go. Mark, if you ever listen to this, what next video you ought to do is do top 10 logical fallacies in court, and go from the most common down to the least common, top 10. Because I think if you could through maybe a video give people a real quick 10-minute lesson on each of these fallacies and how they're in court and how to counter them, and and all this, I think that will really help people to familiarize with it, themselves with it, and be able to call it out on the fly as it's happening in real time, in court, and be able to, to just instantly be able to counter them. So, yeah, I think that'd be a great idea and a great video to really get into to help harden, people, especially newer people, into countering, these bureaucrats. So that's one of many videos that should be on the to-do list.
Yeah, definitely. I mean, I'm actually planning on writing a book on it, on logical fallacies.
Absolutely.
Just to do with courtrooms.
There's so much to say, I mean, especially if you spend any time in the courts, and it's not anything that too many people talk about. So it's certainly under discussed as well. It's a very underrated issue. Logical fallacies.
Yeah. But fallacies you can have multiple fallacies in one sentence, and you can have one fallacy that can actually be 2 or 3 fallacies in one sentence, and a fallacy can sometimes mean a couple of, like even one particular fallacy you can point out can actually mean another one as well. You can choose either one.
When you go to court, you're pretty much going to the logical fallacy Olympics, is what it is.
Yeah. Oh, yeah. The entire system's founded on that. Yeah.
Right. You won't get any better performances of logical fallacies than you will in a courtroom questioning the evidence. Nowhere else.
Yeah. But those are the 2 main ones. It's circular logic, usually most of the time, and it's it's platitudes as well, of course. But it's it's the straw man attack. They'll make some sort of ad hominem attack against you, but it's usually circular logic. It's like the law applies because the law says so, and the statute says this, so therefore it applies, sort of thing. It's like, well, no, that doesn't make any sense. That doesn't follow.
Or in logical fallacy terms, a non sequitur, right? Doesn't follow.
Yeah, to a degree, but you come up against biases and all that sort of thing as well, confirmation bias and
conformity. Yeah,
it's a bigger subject than most people give it credit for in that respect, because we use it in everyday language. Just about everything we talk about in life and in everyday conversations, we all use logical fallacies, all of us, and usually we commit sort of bias fallacies and all sorts as well. For the most part, we can get by without it being too much of a problem, but when you're dealing with this sort of thing, it's a really big problem, because someone's ultimately taking control of your life and potentially ruining it, or at least making it harder than it ever has to be.
Yeah, to say the least.
So that's why it's important to understand them. Yeah.
Okay, I'm going to call you tomorrow, Vin.
Okay, mate. Great.
Thanks, Calvin. Bye.
Yeah, no problem.
Right.
Welcome to the Galileo Club. You're in good company here.
Thank you.
No problem.
All
Well,
right.
you take care. Good luck, and let us know how things go. Okay.
Okay.
All right.
All right. Take care, guys.
Yep. Take care.
Yeah. Take care, mate. I'll catch you later.